Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the State Court Administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also
All rise, the Honorable Chief Justice and Justices of the Supreme Court.
afternoon. Please be seated. We are here at the time set for oral argument in file number 2025-0328, North Dakota, State of North Dakota and the Department of Water Resources versus Virginia Leland et al., including Whiting Oil and Gas Corporation and the State of North Dakota and Virginia Leland as cross appellants. Appearing today and arguing today, our counsel for the state, Zachary Pelham, will be arguing. I understand you have 10 minutes for rebuttal, Mr. Pelham.
That's right.
You're jumping the gun on me a little bit. I have a few more people I'm going to introduce, but we have Mr. Sagsveen, who is appearing, and Mr. Wald, who's also appearing. Counsel for Applee Norby is Ariston Johnston. Applee for the Kuykendall family is Mr. Chapman, Kevin Chapman, and for Whiting Oil is Paul Forster. Sitting today is Justice Daniel Crothers, Justice John Jensen, Justice Jared Tufte, Justice Douglas Barr, and I am Lisa Fair McEvers. Please proceed when you're ready, Mr. Pelham.
May it please the Court, Chief Justice, Justices, Counsel, Zachary Pelham on behalf of the State of North Dakota, Special Assistant Attorney General. The state owns the North Island and the West Bank Island, and this Court should reverse the District Court's decision to the contrary. Alternatively, as to the West Bank Island, at a minimum, the state owns 50% of the mineral interests as a matter of law. This Court should also affirm the District Court's determination that the West Bank Island formed as an in-channel island and that laches does not apply. As to the North Island, specifically, reversal of the District Court decision is appropriate because the appellees failed to meet their burden to prove the North Island formed from an avulsion pursuant to North Dakota law and the District Court's improper application of the law. Specifically, the District Court failed to recognize the presumption that exists of formation that island is formed by accretion, alluvial accretion in this instance. This was disregarded by the District Court, and the Kuykendall appellees did not overcome the presumption. Under 470606, avulsion is statutorily defined. It requires, according to statute, sudden violence or a considerable and distinguishable part of a bank and bears the opposite bank or to another part of the same bank. So here the expert testimony of the appellants effectively was photographs between 1939 and 1949, and their aerial photographs, and they're part of the record, was sufficient in the expert's mind, as well as the District Court's determination to effectively prove avulsion. However, at the same time, there's no evidence that was presented or testified to by these experts as to the actual event, as to when it occurred over the within that 10-year period. Testimony to the contrary by the state's expert was that the formation was by accretion, and that was gradual. So the expert of Kuykendall's testified, quote, slow and progressive change, end quote, occurred, and even disagreed with the statutory definition of avulsion in North Dakota. The state's expert, again, testified that formation occurred gradually. So as a matter of fact, that's been presented, the factual evidence, as well as specifically here the law. The District Court's disregard of the statutory definition of avulsion at the expense, effectively, of dismissing the presumption that exists under the law, which is the Woodland case that's cited in a brief, that essentially states that the presumption is the island forms by accretion. So the rebuttal of that presumption did not occur, first, and second, even if it could be argued that it did occur, the rebuttal testimony is effectively photographs, aerial photographs that are record evidence of the avulsive event, but not indicating as to any specific point in time or its circumstances as to what that avulsive event was. We also argue in the alternative
Mr. Pelham, is that an insufficiency of evidence argument? You're clearly attacking the court's findings, so what's our avenue of analysis?
The avenue of analysis, Justice Crothers, is a failure to adopt the presumption that exists at the expense of...
So where does that get us?
Where that gets us is a failure as a matter of law to apply the law as the statute and case law recognizes as to what the formation of an island is. And that evulsive event that was testified to by the appellants simply was not proven. And quite frankly, the evidence that exists is contrary to law. And that was adopted by the district court as a result of that adoption of an erroneous view of the law. Reversal is appropriate. The presumption is established because there is no evidence to the contrary of an evulsive event, so the North Island is owned by the state.
And did I recall that you cited 470606 in support of this argument?
That's correct.
Does that apply to islands?
Yes.
I thought it was banks.
Well, it has application. If you look at the Woodland case, it certainly has application as to presumption. So it
What does
applies.
the statute say, though? It refers twice to banks, or many times to banks.
I think the interpretation of the statute is if a river navigable or not navigable carries away by sudden violence or considerable indistinguishable part of a bank and bears it to the opposite bank or another part of the same bank. So it's talking about a bank, but it's also talking about the river.
Banks aren't islands.
Sure, but their argument is that effectively that the North Island was formed out of that bank and out of that evulsive event. Our argument is that it was through the formation of an in-channel island through accretion, alluvial accretion. So there's certainly a difference of opinion as to that, but the acceptance of the evulsive event, Justice Crothers, by the district court is erroneous as a matter of law because the presumption is, one, that the island is created through accretion, and if that's not rebutted, there has to be some sudden change to the bank that it breaks off in the manner that's stated in the statute. We also alternatively argue that the appellants did not present any evidence that they reclaimed within a year, which is also required under the statute. Specifically as to the West Bank Island, phase one of the trial the district court determined correctly that the Yellowstone River was navigable at statehood and the West Bank was owned by the state unless there's a deed or other conveyance impacting ownership. So phase two of the trial was held in January of last year, and the court determined that a 1950 special warranty deed effectively took away land that the state owns through the determination that an in-channel island that formed the West Bank Island. And there's a few different areas that we take issue with that. The first is primarily on the face of the deed itself. And then we argue an alternative argument that there's an ambiguity in that special warranty deed. And then we also argue, as another alternative, the reservation of the mineral, the oil and gas rights as to that. So first off, on the face of the special warranty deed, it specifically conveys lots 1, 2, and 3 in section 31, less parts eroded by the Yellowstone River. So looking at this and going back in the record, I think it's important to bear out docket number 425, which is the original patent. So if you look at the original patent from the United States government to the original owner, Nels Walla, in, I believe, 1911, might have been 1912, but the original patent contains some language. After the handwritten description of the legal description on the acreage, the patent states, quote, according to the official plat of the survey of the land returned to the General Land Office by the Surveyor General. So we have specific language in the patent, and the appellees have attacked this deed saying, well, it's not conveying riparian lots. These lots are bounded by the Yellowstone River. There is, if you look at the survey from 1901 that was established, that established the lots, the acreage and the legal description of the lots, there can be no dispute that these lots, the western boundary of these lots, make them riparian lots. They are subject then to the movement of the Yellowstone River. And secondarily to that, the deed, the 1950 deed, specifically, as well as the 1941 contract for deed, which forms the basis of the 1950 deed, specifically contains the language less parts eroded by the Yellowstone River. The appellees cite to the aptly named Norby v. Estate of Kuykendall case, which this court decided some years ago, which did not involve the state of North Dakota, which did not involve these lots. And I just want to read a portion of that decision as paragraph 3 of that decision, which is cited, the decision site is in our brief. It's, quote, in 1984, Richard and Rocky Norby purchased a section of Richland County, Montana property contiguous to the Kuykendall's property in North Dakota. The deed from which the Norbys received ownership, the Montana deed, does not describe the Yellowstone River as the boundary line of the property and grants them property located only in Montana. So here we have a situation where the Yellowstone River is meandering, it's moving from the original survey in the early 1900s, and we know that from the Montana survey as well as the North Dakota GLO survey, which are part of the record. The Yellowstone River is moving from the west, the Montana line, which, mind you, the Montana-North Dakota line is not determined by the Yellowstone River. That line is established, I believe, by act of Congress. It's in the briefing. So as the Yellowstone River is moving, it is moving to the east. And the district court here determined that the West Bank Island formed as an in-channel island. It subsequently moved, and if you look at the aerial maps from 1939, 1949, and subsequent up to 2018, you'll see that the island does attach to the western bank of the Yellowstone River in Montana. So if you look at a map in 1918, well, how is this an island? Well, it was formed as an island. And the district court properly determined that, and that is what this court should affirm as far as that determination that it formed as an in-channel island, and specifically that, this is my spot here, that it formed as an in-channel island, and as a result, that acreage that we're talking about in the 1950 deed does not in any way convey anything that the state of North Dakota owns, sovereign land, from that creation of the in-channel island. So you have a situation where an island arises, a navigable river, part of a riparian owner's land. Such owners cannot claim title thereto by reason of their riparian rights, though the island is afterward joined to their land. And that's the Hogue case versus Bourgeois, and that is cited in our brief. So effectively, once an island, always an island. So we have here, we have an in-channel island that was formed by in the river and then eventually attached itself to the western side of the Yellowstone River. But then you have on the eastern side of eastern banks of the Yellowstone River, you have lots 1, 2, and 3 in North Dakota, across from the creation of the island over here. And you have the Yellowstone River moving then to the east, eroding the land of section 31, lots 1, 2, and 3. And we see that in the aerial maps, and we see that the West Bank Island is accreting land from the west to the east. We don't have accretions from the east bank to the west. So the western bank, the western boundary rather, of lots 1, 2, and 3, which is the Yellowstone River, is not moving westward. It is moving eastward, eroding into the Yellowstone River. With the movement of the West Bank Island from Montana state line westward, or rather eastward, that is creating accreted property that is still sovereign land owned by the state of North Dakota. And that's where the Hogue case comes into play, because there the Hogue case talks about what happens when you have a situation where there may be some accreted land, but some eroded land. That point of meeting is that property is still owned, once an island, always an island, for the state of North Dakota. So nowhere did the state concede lots 1, 2, and 3 were anything other than what was surveyed lots originally in the 1901 survey by the GLO. So as a matter of law, on the plain face of the 1950 special warranty deed, the only thing that was conveyed was lots 1, 2, and 3. The West Island was not conveyed.
So lots 1, 2, and 3 at the time of conveyance, where's the west side of those lots? The river or Montana, according to the state's position?
Well, the lots never abutted the Montana state line, ever. Those lots, if you look at the survey, Justice Crothers, were always and only ever on the eastern bank of the Yellowstone River. And they eroded, those lots eroded to the east. And so those lots, if you look at the survey, which is incorporated in the patent, were never all the way to the Montana state line.
Was the state line in the river at that time?
Was the state line?
Was the state line in the river at the time?
A portion of it was, yes. If
The
you look at
portion
that,
relating to these 3 lots, was that part in the river?
in 1901 when the GLO survey was done, no, the river was not. I mean, if you look at that survey, Justice Tufte, the survey shows specifically where the western boundary of lots 1, 2, and 3, and that's the eastern bank of the Yellowstone River, which is not the Montana state line. And that much is evidence from the survey itself. So as the Yellowstone River moved eastward, it would be impossible for accretion to occur from the western set boundaries of the lots because the land eroded into the river as the river moved east. So stated another way, the West Bank Island did not form from the lots, having rose from the navigable riverbed as an in-channel sandbar and grew into an island. And we do not have the lots gaining by accretion, as the western boundary did not move east. Rather, it was eroded into the river, gain by accretion, lose by erosion. This court should reverse the district court's summary judgment decision and confirm that the 1950 deed's conveyance of the lots did not affect the state's ownership of the West Bank Island and all of its minerals. Alternatively, we argue that if the court disagrees with that argument on the face, there is an ambiguity specific as to the special warranty deed. We've laid that out in our brief. Specifically, the ambiguity is what does less parts eroded by the Yellowstone River mean? We've not had anyone that's been able to define that term specifically. Less parts eroded by the Yellowstone River, we argue, is set forth in extrinsic evidence that was presented as an offer of proof at trial, as well as in response to the summary judgment motion, which I know the appellees argue that we waive, which we did not. We certainly preserved that argument and argued that numerous times at the district court as to that specific issue. So the Bank of North Dakota records, what are they? Essentially, those records form the basis of the bargain, the 1941 contract for deed that was entered into between the state of North Dakota and the Wallace. Effectively there, you have a situation where the bank is looking at it, hey, we made a loan here. Most of the land is eroded, and there's only about 70.8 acres that are left of the 145 acres that were originally part of the original loan. We're going to lose money on this one, but we're going to not lose as much money if we take the $708. If you do the math, and we've done the math in the brief, I won't go through that here, but effectively the math supports what we're saying. There was not a conveyance of 144.65 acres.
When we're determining whether a deed's ambiguous, is that something you can determine by just the 4 corners of the deed? Or is it sort of ambiguous in application? Do you have to know what the facts on the ground are?
I think that's a good question, Justice Tufte. I think here in this instance, I'll answer the question this way. I think, one, if the court rejects our argument that we think that the deed is plain on its face, it doesn't convey any part of the West Bank Island, it only conveys lots 1, 2, and 3, then, we're not looking at it. But if we have a situation here where we don't know what less parts eroded by the Yellowstone River means because the acreage isn't clear, well, then I think we look to extrinsic evidence in that case. And that's a legal decision which the district court believed did not exist, even though presented with evidence that it was. Certainly, there's an argument that the state somehow waived that or stipulated away that. The stipulations that are in question are, I believe, docket 273, and then there's some documents that went through which different scenarios in the event of the court finding a certain way. In no part did we stipulate as to any of those potential scenarios. We only stipulated as to the acreage in the event that they would happen. And in this event, just briefly finish here.
Right.
In this event here, we had a situation where the court sided with us and said that the West Bank Island formed as an in-channel island, and therefore that particular portion of the stipulation applied. And if you look at that particular...
Mr. Kellum, you're going to have to conclude or start on your rebuttal time.
Okay, just very briefly, Chief Justice,
You're in your rebuttal time.
Thank you. The specific stipulation portion has 0 acres as far as lots 1, 2, and 3. Thank you.
Mr. Johnson, excuse me, I understand you're going to be arguing first, so you have 7 minutes.
Thank you, Madam Chief Justice. May it please the court and counsel, my name is Arston Johnson. I represent the Norby family in this matter, as I have done for some time. Most of you saw me about 12 years ago on this land, but indeed the state was not a party to that. I'll come back to that. By way of introduction, our position is that regardless of how the West Bank formed, the district court found it formed as an island in the channel of a navigable river, but regardless of that, the state conveyed that land to the Wallas with that special warranty deed with the warranty of title. This court can and should affirm the judgment below without disturbing any of the factual findings. I'll talk first about waiver. The state in this case cannot change the framework of the case after summary judgment has been fully submitted. And if you look at the docket, the record below, the state's first claim that the Bank of North Dakota records had anything to do with the meaning of this deed came after the summary judgment argument. That argument was on November 8th of 2024, and the first claim regarding the Bank of North Dakota records affecting the deed's meaning was the state filing a motion to supplement that record on November 14th. The summary judgment was decided on December 19th, and only after that did the state for the first time raise the claim that the deed was ambiguous in its motion for reconsideration January 14th of the next year. For those reasons, the court can and should affirm those issues and the judgment below on waiver grounds. Turning to the interpretation of
Just a second, is the question of whether a deed's ambiguous a de novo question on appeal?
It is, but it does have to be raised below. So the question of what a deed means is a question of law, unless it's ambiguous. The question of whether it's ambiguous is a question of law. Turning to your earlier question of counsel, the ambiguity should be shown on the face of the deed, and there isn't an ambiguity here. And I'll talk about that now. The state's argument is that the Bank of North Dakota records are the best evidence of what that deed means, but that's legally incorrect. The only evidence of what an unambiguous deed means is the deed itself. This deed passed riparian rights unless they were expressly reserved. Silence is not ambiguity. The North Shore versus Wakefield case makes that clear. And in this case, the district court did not ignore this reference to the river eroding the land. Rather, it understood what that reference means. What it means is that the state reserved its equal footing interest in the riverbed, so that the river, as it moves, continues to belong to the state. But above the high water mark, this deed conveyed the land. The REAP case makes it clear that the state can convey its equal footing interest if it does not reserve it in a deed. In this deed, it did that. So the district court gave meaning to every word and every clause in that deed by by concluding as a matter of law that it was not ambiguous and conveyed this land. Turning to the Bank of North Dakota records, even supposing they could be used to show an ambiguity, or even supposing there's an ambiguity that they could resolve, they wouldn't. They were never presented to the Wallace. They couldn't be part of the bargain if they're a one-sided thing. My interpretation of the Bank of North Dakota records is that the Bank of North Dakota had a misconception of what the law would do with this land and with this deed. That internal misunderstanding of the law or mistake of the law does not bind the other party to the deed. In the state's reply brief, this is regarding what that deed conveyed and what these lots are. Paragraph 31 of the appellant's reply brief includes a picture of the state's Exhibit 101 from trial. If the court looks, and that's docket 287 in the record. State's Exhibit 102, docket 288, is an explanation of that map of these lands. And in the explanation, we have government lots 1, 2, and 3 identified as these lettered parcels, and the lettered parcels are shown going to the state line. You can also compare that with Whiting's Exhibit 219A, which is at record 509 from the second phase of the trial, showing the same thing, that these lots extend to the state line. The settled law in North Dakota is clear that these parcels being defined by government lot numbers, not by reference to the river as a boundary. There's no reference to the river as a boundary. In that situation, what we have here, the movement of the river, when it causes lands to re-emerge, the re-emergence doctrine causes it to be the possession and property of the original title owner. And although the state was not a party to that case and would not be bound by the judgment in that case, the state is bound by the law of North Dakota as spelled out by this court in Norby v. Kuykendall, 2015, North Dakota 232. So this court could affirm on waiver alone, but if you go beyond that, this court can also affirm on the meaning of the deed without addressing latches or any other arguments. On latches, I first call the court to a drafting error on my part, and I apologize for it. Latches is a finding of fact subject to the clearly erroneous standard of review, which I correctly said, and then promptly described a different standard of review. Please disregard that paragraph. It is clearly erroneous. But it is clearly erroneous if it's induced by an erroneous view of law, if no evidence supports it, or if after reviewing all the evidence, the court is convinced a mistake has been made. And I note in the Stengham versus National Audubon Society case, there's a little bit of confusion on the law of latches. The element is described by citation to Johnson v. State as a change in conditions during the delay. In the same paragraph, there's a citation to Bakken v. Duscher regarding the claiming party being prejudiced because his position has been changed during the delay. Regardless of that, the district court said there's no evidence of a change in position or prejudice, and there clearly is, and it's clearly erroneous to say that. Both the conditions and positions of the parties were changed. They bought this land, paid taxes on it for decades. There's loss of physical evidence over time, loss of witnesses over time. I had to substitute my client because my original client passed while this case was pending. Many others went before in the 130 years or the 70 years after the special warranty deed. We had to hire geology and tree ring experts when, not to be too glib about it, all the facts of this case could have been resolved with 2 canoes 100 years ago by canoeing on either side of the island that was supposedly there to show that it was an island in a navigable channel. So this court can affirm the judgment by reversing on latches, which would render all other errors meaningless. I thank you for the time, though it was limited, and appreciate the court's time today.
Thank you, Mr. Johnson. Mr. Chapman? And I understand you have 8 minutes.
Yes, Madam Chief Justice. Madam Chief Justice, Justices, Council, Mellon family, Kuykendall family. I represent the Mellon group who own the North Island, and I represent the Kuykendall group who used to own the West Bank, but now Norby owns the West Bank, but Kuykendall still own minerals underneath the West Bank. And here's how I know that the Mellons own the North Island. They homesteaded it starting in 1907. So their parents, John and Olena, homesteaded this land, and they farmed it.
Which island are you?
North Island, I call it
Island?
North Island or Leland Island, Your
Okay,
Honor.
North Island, okay,
And
thank
the
you.
district court found that we own it. The state does not own the North Island, which is 100% correct, because the Mellon family have owned it since 1907. Their blood, sweat, and tears went into farming this land. Their father was in the Navy in 1948, because he got it from John and Olena, eventually. He got a letter indicating that John and Olena were going to lose the farm because of finances. So he hitchhiked, got an honorable discharge from the Navy, he hitchhiked back and took over the farm. By the time he got to the farm, he had already auctioned off the equipment. So their dad toiled night and day, farming, working odd jobs to save this farm. This is the exact land that the state is claiming that it owns, which they don't own. As the Honorable Robin Schmidt correctly analyzed, there is absolutely no evidence that this was from accretion. And so when you look at page 8 of my brief, I have the two exhibits that the judge relied upon, the two pictures, one from 1939 and one from 1949. This is 100% just regular farmland on the left. This is the land that the Mellon family have farmed since 1907. It's north and east of the West Bank area, and it's not part of that analysis at all. It's a completely different analysis. And when you look at the difference between 1939 and 1949, as Judge Schmidt so aptly noted, there is no way that this could have been fully accreted away and then reestablished in a 10-year period of time. So an evulsive event or multiple evulsive events did occur. Now the state was just up here arguing, well, the judge didn't apply this alleged presumption. The judge never said she didn't apply the presumption in favor of accretion. That's no place in her decision. That argument is a complete red herring. The judge's findings of fact with respect to the North Island, also known as Mellon Island, is she heard all the evidence, our expert testimony, everything, and the pictorial evidence that is available, and concluded and made findings of fact that there is absolutely no evidence that an accretion could have wiped away this land and formed an island in the exact same form as this existed in 1939. And I'd like to point out another point with respect to the state's arguments. They want to talk about evidence. Well, let's not wait over a century before we attack ownership of somebody's land, especially when they've homesteaded it since 1907. So the state comes in and they say, well, what evidence is there? Well, that's where laches comes into play, not just on the North Island, but on the West Bank as well. And the state is on constructive notice of deeds that get entered into. They're on constructive notice of the fact that the Mellons have owned this land since 1907, homesteaded it. Despite the fact that they're on constructive notice, they don't do anything until 3 years after Whiting filed the initial lawsuit, simply because Whiting didn't know who to pay. And they had to bring everybody in that was mineral owners. And it took the state another 3 years after that litigation started before it decided, oh yeah, let's bring in the landowners for the West Bank. And as a complete afterthought, they decided to bring the Mellon Group in and try to get the North Island away from the Mellon Group. When Dr. Day, the state's expert, was questioned at trial about whether she can form an opinion as to the North Island formation, her exact words was, I think I can. I think I can. Now, that is not very persuasive evidence. when an expert just says, well, I think I can. They didn't analyze the North Island at all. Their report did not deal with the North Island. On questioning, Dr. Day candidly admitted that her report, even as to the West Bank, was completely full of uncertainty. Why was it full of uncertainty? Because nobody did anything for over a century. Nobody did anything. The state's on notice. Yeah, the Yellowstone River moves, it shifts. The state's on notice. Those deeds and the maps go all the way to the North Dakota-Montana border. I'm talking about the West Bank now, not Leland Island. They clearly show the North Dakota-Montana border as being the western border of lots 1, 2, and 3. It's always been determined that way. Butch Kuykendall in 1967 purchased the West Bank from his parents. His parents purchased the West Bank from the Wallace. The Wallace got the West Bank from the special warranty deed that Ari and Zachary were talking about earlier. Why would they buy this land? As testified to by Butch Kuykendall at trial, he needed more surface land to establish more grazing units. This was ground, and it was ground all the way up to the Montana border. The idea, and the state throughout this litigation has treated lots 1, 2, and 3 as going all the way up to the West Bank. It was after the summary judgment was entered and they realized that they just lost the West Bank, they filed a motion for reconsideration trying to bring in ancient bank records that allegedly try to explain a non-ambiguous deed. And the judge clearly and rightfully ruled that that's not correct, that evidence isn't coming in. So a lot of what the state argues in their brief, and even today about what land was conveyed with respect to the West Bank, it shouldn't be at issue because it was not properly raised, number one, and furthermore, all the evidence showed that it was the North Dakota-Montana border. Thank you very much for your time.
Just one quick question, Chief.
Yes.
Yes, go ahead.
The district court cited but didn't seem to apply 470610, which is titled Islands Formed by Dividing a Stream. Can you speak to whether the parties argued that section of the code to the district court?
That particular section, Your Honor, it does not ring a bell with me anyway with respect to the North Island, because our expert clearly indicated that it was an evulsive events or numerous different evulsive events throughout that 10-year period of time. The state's argument that it took place gradually over 10 years, that's not what any testimony was and was not what the judge decided.
Okay,
Thank you, Your Honor.
Thank you, Mr. Chapman.
Thank you.
Mr. Forster, you have 5 minutes.
Thank you, Chief Justice. May it please the court, Paul Forster on behalf of Appley Whiting Oil and Gas Corporation, who operates an oil and gas well on the property that's at issue here. And we initially kicked off this lawsuit almost a decade ago as an interpleader action to deposit funds and determine payment of those funds, which is going to require a determination of ownership here. I'll spend most of my time today talking about that mineral reservation issue that I addressed in my brief, but at the outset, I just wanted to flag briefly a footnote concerning the timeliness argument that the cross appellants have made against the state. And the note is this, that no party has argued that Whiting's interpleader and mineral quiet title claims are time barred. And indeed, those claims need to be resolved in order to distribute the funds that are on deposit with the district court. And so at the end of the day, I think we don't take a position on the cross appellants' arguments, but just so it's clear, the court needs to determine who owns this, what the acreages are, and so forth in order to resolve those claims, which have been resolved by the district court and should be resolved in this case. So That said, Whiting isn't taking an issue on the majority of issues that are on appeal here, but we did oppose the state's alternative argument regarding the size of that mineral reservation under the Walla conveyance. If the Walla conveyance did in fact convey part of the West Bank to private owners, as the district court held, then the size of the state's mineral reservation, their statutory reservation, was 5%, not the 50% that the court argues. And that's consistent with the plain language of the governing statute, with on-point North Dakota Supreme Court precedent directly on point, not to mention the plain language of the contract and the deed themselves. So let's start with the language of the statute, because the parties seem to agree that the statute controls the size of the state's reservation. That statute is 380901, and it provides a statutory mineral reservation to the state that applies in every transfer of land, whether by deed, contract, lease, or otherwise, by the state of North Dakota. So the statute applies expressly to contractual conveyances, and it only applies to transfers, quote, by the state of North Dakota. So where does that leave us when we have a contract for deed like the one here? Well, black letter law in North Dakota is that a contract for deed conveys equitable title to the vendee under the contract, such that the vendee can then transfer those equitable property interests to a third party, as happened here, and the ultimate deed merely perfects title relating back to the date of the contract. And that reasoning that I just laid out is directly from this court's Hokanson versus Ziegler case, which we rely on in the brief. That case involved analogous facts to those here. It involved a contract to sell land from the state to a private party, followed by an intervening change in the size of the statutory reservation. And in that case, the court held that the date of the contract controlled the statutory mineral reservation to the state, not the date of the vendee's conveyance to a third party, and not the date of the ultimate patent in fulfillment of the contract. That same principle, by the way, is embodied in Mineral Title Standard 2.02.2, which is cited in our brief, and that's because it's an important principle in mineral law and in the state's mineral title. And the state's arguments to the contrary here, their arguments for a 50% reservation, frankly lack merit. The correct reservation size is the 5% that was in effect on the date of the contract for deed here. Now, the state, one of their arguments is that they want to urge that an assignment of a contract for deed is itself a transfer of land. And then they kind of build up this straw man suggesting that Whiting is arguing to the contrary. We've never disputed that an assignment of a contract for deed transfers land. It does, it transfers the equitable title. The problem for the state is that so we agree it's a transfer. The problem for the state is that it's not a transfer by the state of North Dakota. And look at the statute, it only applies to transfers by the state of North Dakota. When a vendee assigns a contract for deed, the vendee is transferring the land, not the state of North Dakota. The vendee is transferring that equitable title that they gained under the contract. Even if the state has to consent, it doesn't change that fact. Thank you.
Thank you, Mr. Forster. Mr. Pelham, when you're ready.
As to Justice Tutsy's question on 4706-10, I don't believe that anyone argued it. As to the North Island, as to the expert of the state not having knowledge, the expert of the appellant's testimony was that, quote, something happened. So again, the presumption is accretion. The burden is proving avulsion. Something happened isn't evidence. Something happened. We know something happened. What happened? We don't have that evidence. Conveyances by public bodies are interpreted in favor of the grantor. That's 4709-13. As to the argument by Mr. Johnson on reemergence, the owner of an island, and this is from the Hogue case, and I think that's especially relevant here, the owner of an island is entitled to land added thereto by accretion to the same extent as the owner of land on the shore of the mainland. If the accretion commences with the shore of the island and afterward extends to the mainland, or any distance short thereof, all the accretion belongs to the owner of the island. But if accretions to the island and to the mainland eventually meet, which arguably happened here, the owner of each owns the accretions to the line of contact. So here we're arguing effectively that the island moved from Montana to the east as the erosion of lots 1, 2, and 3 occurred, and the west bank occupies what was once lots 1, 2, and 3, or portions thereof, and the state owns the island, because once an island, all is an island. We don't have any evidence of accretions from the western bank, or rather the western boundary of lots 1, 2, and 3 that would have somehow magically moved to the west. They didn't move to the west. It did not move to the west. All the evidence in the record is that the river moved to the east and eroded that land.
Mr. Pelham, you mentioned several times, once an island, always an island. What if land that was deeded to a private party from whomever it was deeded, but originally would have come from the state, becomes an island? And then does it become state property? When you're saying once an island, always an island?
Sovereign land, I believe, would be the case as an instance. I don't know as to your hypothetical, Chief Justice. I'm sorry. It's a very good question. I just don't know the answer to that question. I don't think that.
And the reason that I ask is that it looks like on the pictures that the North Island splits the river, correct?
The North Island is still very much an island, right? And
Has it always been an island?
I mean, no, because I mean it formed by accretion. So I mean it was on the bank of it was in section 30 at one point in time, but between 1939 and 1949, the evidence, rather the presumption is that it formed by accretion. And that's the argument of the state that was presented at the phase 1 of the trial, was rejected by the district court, and we're arguing that is contrary to law. Specific as to other arguments that the state has made as to what it has appealed, the alternative argument that Mr. Forster just got done outlining as to the meaning and application, rather, of 380901 to the situation here is the alternative argument that if the court rejects our argument that the state owns 100% of the minerals, that at a minimum it owns 50%, given the application of 380901 to the situation here. Certainly the Hawkinson case stands for what it stands for. Here, though, we have a situation where we have interpretation of a statute that doesn't recognize the difference between equitable title and legal title. Certainly a contract for deed conveys equitable title. That's basic law school, property law 101. But here we have a situation where in the contract for deed, there is a requirement that any assignment be approved by the state of North Dakota. That approval didn't occur until 1947 in the assignment. So what is the effect of that? The effect of it has to be something, and that's essentially our argument. It is something because it means something. The statute has to have meaning because the legislature doesn't do idle acts. Otherwise, the statute, which talks about deeds, contracts, leases, or other transfers of any such land after February 20th, 1941. So then the assignment effectively, for purposes of this statute, is meaningless, is what the argument of Whiting is, and the state disagrees with that and has argued that that assignment changes, transfers, and because of that, the wording on the statute means what it says and should be applied as it's drafted.
But how is it a transfer by the state? That's the argument that was made by Whiting.
Because the contract for deed, Chief Justice McEvers requires the state to approve any assignment, so it relates back in that respect. So the timing of when that occurs is the operative point. So in 1947 versus 5 days prior to the effective date of the statute, which is interesting, but is the case here in this instance. 5 days before the contract deed was signed, if it would have been signed 6 days after, then we wouldn't be here talking about this issue. But here we have a situation where these two new individuals received a right from the state of North Dakota to receive the eventual special warranty deed in 1950 upon the uniting of the equitable and the legal title.
So help me understand the timing there. So just before the assignment, the state had reserved 5%, right?
That was the law then, yes.
And if the original vendee had paid the rest of the contract, there would have been a 5% reservation, right?
According to Hawkinson,
And
yes.
so the state consenting to this transfer from the first vendee to the second vendee receives back 45% by consenting to that transfer?
Well, I don't know if that terminology I would quite agree with, Justice
Fair enough.
Tufte, but I think that the operation of the statute is that any contract, lease, or other transfer of any such land made after February 1941 means that the state that has to reserve 50%. So yes, that's,
It looks like it's more a conveyance to the state than a conveyance from the state.
well, the state is conveying what it owns. And again, there's a disagreement on what it owns as to lots 1, 2, and 3, certainly. But what it is that the state is owning, it can't convey by operation of statute more than 50% of the minerals. And that's the basis of the argument.
Okay.
The argument that was made by, I believe, Mr. Chapman, related to latches and statute of limitations, that was argued in the Kuykendall brief specifically that they they acknowledged, not finally, that's not fair, they acknowledged that 280101, which is a 40-year statute of limitation, applies. So that was the first time it was argued that the claim accrued in 1958. So we argue that because they have not argued that, the court should not address that. But even if the court does address it, that the 40-year application, that statute of limitation commenced in 1987. And if you look at docket numbers 347, 348, and 349, that forms the basis of when it was realized, because you had a lease that was advertised in the newspaper from the state of North Dakota for this property, and then you had a letter dated May 18th, 1987 from Mr. James Kuykendall to the state, and then you have a response, docket 349, specifically outlining this issue. And I think it is an interesting read as far as the letter between, but given the state of my time, I will not read that and would request that the court consider that language in there. It certainly is the first time that anyone had any knowledge. As far as the state taking its time between the Whiting complaint, the state had to make first sure that what it was claiming was supportable, and that's what it was doing in that instance, retaining experts to prove the West Bank Island formed as an in-channel island, and in the case of the North Island, not prevailing on that, but making good faith arguments, and then as to the South Island, which is a part of this appeal, to succeed on that argument. So, in conclusion, this court should reverse the district court's determination as to the North Island and determine it was not formed by an avulsion and owned by the state, and the state owns 100% of the mineral interests. The court should reverse the district court's determination as to the West Bank Island and determine it is wholly owned by the state, and the state owns 100% of the minerals. Lots destroyed through erosion do not reappear on the opposite bank of the river. Finally, the court should affirm the district court's determination that the West Bank formed as an in-channel island. Thank you.
Thank you, Mr. Pillam, for your argument. And Mr. Johnson, Mr. Chapman, and Mr. Forster, thank you for your arguments as well. This case will be taken under advisement, as all cases are, and this court will be adjourned until Thursday, February 19th,